Thank you for joining us. I'm Charlie Plumb, and I want to welcome Kirk Turner and Paul Ross. We've been obviously dealing with a lot of questions day to day from employers involving COVID-19. It's a fast-moving and fast-developing subject. We thought it would be helpful to get in your hands some very practical and usable information that you're probably facing right now. We think it's important. The planning aspect is very important for employers to stay away from panic. We also want to really encourage communication with our workforce. It's good. I think we're putting this together today. I think the advice we're giving today, because of how fast moving and evolving this is different advice than we would have provided to employers a week ago. And I think don't be surprised from Paul or Kirk suggesting things that maybe are different from what we've told you in the past on legal issues for employers, because we're facing really a new world here with some very serious issues that involve safety and health of our workforce, safety and health for our business associates and our customers. So frankly, we're going to be a lot more proactive in our advice and recommendations. Some of this legally is a gray area. Some of this we're going to be pushing the envelope. But again, I think when we're dealing with the safety and health of our workforce, it merits that kind of treatment. So please, as new issues develop, don't be shy in asking us questions. So I want to start, Kirk, with you. Really, one of the first questions we're getting these days is, do I, as an employer, I've got a sick employee, and I may not even know whether they are positive for COVID-19, but I know they're sick, they're exhibiting some symptoms. What sort of ability do our employers have to say, hey, Charlie, you need to go home, whether Charlie wants to go home or not?
Yeah, it's a great question, and one that is happening all the time. We have an obligation under the Occupational Safety and Health Act to provide a workplace free from any known hazards, and certainly exposure to COVID-19 with the transmission of it and the contagion of it is certainly that. And so I think we certainly have the ability to send people home if they are exhibiting symptoms, not because they're of a particular class, not because they're of a particular age, but because they are exhibiting some symptoms that would be consistent with what the CDC is telling us as it relates to COVID, which are respiratory issues, which are fever, which are the coughing, constant coughing. Those are the kinds of things that you want to be looking for, and your managers and supervisors want to be looking for in addressing whether or not we should send somebody home, for sure.
Paul, what about your thoughts? Maybe someone shares with you, an employee shares with you, they're not feeling well, or a co-employee shares that, and you hear that through the grapevine. What are your thoughts about the ability of an employer to say, I need you to go home?
Yeah, I think the advice I've been giving employers is that you basically have limitless discretion when it comes to sending an employee home who is exhibiting symptoms of a respiratory illness. And I think it's important to remember that the agencies that typically regulate our conduct, the EEOC, et cetera, are all issuing guidance that says, that is essentially deferring to the CDC. And when the CDC recommends that employees exhibiting those symptoms go home, we can act on that. And so I think it's the best advice, and probably the most important question we can answer right now is that employees exhibiting active symptoms can be sent home, whether they want to go home or not.
I would say the other thing that we want to make sure is that we can't require them to go see a doctor, but we should certainly encourage them to go seek medical attention, and then we can set a parameter for how long people need to be gone. CDC says it's between 2 days and 14 days of exposure, so I think most people are using the 14-day window as a time limit. By said, hey, Paul, if you're exhibiting symptoms, you need to be gone for 2 weeks, and then either return to work with some doctor's note that says you're okay, or with that you're free of symptoms. We don't want you to come back if you have symptoms.
All right, Paul, a little bit of a twist on the question that Kirk answered. You've got an employee, no symptoms observed, but he or she has just returned from a trip to fill in the blank, a cruise, a trip to Mexico, overseas or domestic travel. Again, someone that's not exhibiting any sort of symptoms, what sort of freedom of action does an employer have, if any, to take action or make decisions on whether an employee comes back to the workplace?
Yeah, I think the situation there is almost identical to a situation where an employee has symptoms. You're going to have the discretion, particularly when you are following CDC guidance regarding what constitutes a high threat of exposure. And so when you're talking about travel from Europe, when you're talking about travel from China, when you're talking about prolonged confined spaces like cruises, you're going to be justified in being exceptionally cautious in returning those employees to work. And I think you have enough governmental guidance at this point suggesting that those are high-risk situations that I think it's entirely appropriate to ask those employees to stay home for the 14-day period. And I think while it's possible that you may have an employee who doesn't particularly like that, I think now's the time for us to err on the side of caution.
Yeah, I would totally agree with Paul. The only thing I would just make sure that we've got to get in our mindset is we have a pandemic. We have a different world today, even on Monday, than we had last Monday. And we have a state of emergencies that's been declared. We have states that are also declaring states of emergency. And so I think our world has changed as it relates to employers' obligation to ensure that we have this safe workplace. And frankly, we do have a direct threat issue, and as we all know from the ADA, we're limited in our ability normally in asking questions or inquiring about health condition or requiring testing of some sort. But I really do believe that we have a really strong position that we do have a direct threat, which is of imminent harm to that employee or to others, and that we should invoke that direct threat analysis in this particular situation.
Well, to follow up on a point that Paul made, Kirk, we said at the outset, we are really advocating with the new world you're describing, a more proactive approach for employers, maybe pushing the envelope. Paul mentioned the ability of an employer to rely upon information the CDC gives. The other thing we're suggesting to employers, don't forget about your local resources, whether it's the state of Oklahoma Department of Health or Tulsa, Oklahoma City, local boards of health. I think not only do you get good information from those sources, but they're going to give advice that you as an employer is both practical, but you as an employer have the right to rely on. We're going to have some situations where employers are going to take some aggressive stands, I think reasonably, and it's going to be helpful to say, look, I am going to stand up for the safety and health of my workplace, my workforce, and I'm also getting that advice from Tulsa County Department of Health, Oklahoma County Department of Health, fill in the blank. That's important. So, Paul, what about employers that find out without any doubt that an employee has been confirmed to have contracted COVID-19? How does that change the landscape?
Sure. Well, I think the obvious and easy answer to that is someone who is confirmed and tests positive for COVID-19, they are going home. They're going to be on leave, and we may have some questions or some issues about whether that leave is paid or not, and we'll certainly address that, and we'll learn more as the week goes on when we see what Congress does with our new legal requirements with respect to that. But the broader questions that we've been getting, rather than questions about leave for a person that tests positive, is what do we do with everyone else? So first, do we have an obligation to report, say, to the State Department of Health that we have an employee who has tested positive for COVID? The answer to that specific question is no, we don't have a legal duty to report that information. But it may make sense to do that for the broader public health reasons.
Yeah, one of the things we're struggling with is getting good information on where it's occurring and when it's occurring. So even though I may not have as an employer an obligation to report to the Board of Health, how am I helping by letting the Board of Health know that I've got an employee? Does that help?
Yeah, I think it does, because then we have better tracking by our government agencies that are managing this crisis of where the disease is and what responses do we need publicly to limit that additional exposure or the spread of that contagion. And so you see, for example, just yesterday when a diagnosis came through of a community based transmission of the condition, you saw our government, our local government, react very quickly to that fact and change almost immediately what our previous responses had been. And so I think it does make sense to very seriously think about whether we should communicate that information to at least the Department of Health, at least while we're in the early stages of the spread of the pandemic here in Oklahoma. So I do think it makes sense to consider that. You don't have a duty to communicate that information, but I think it's probably for the greater good that we very seriously consider doing that.
And the other advantage is, we just spoke to this, is you're going to be getting quality information on what you as an employer should be doing, what sort of steps, when you have that sort of confirmation of information.
Right. And then, go ahead. No, I was going to say one other thing that I think is on a related point. When you have an employee who tests positive, we have a confirmed case of a person who has been on a site. Now we have to decide, who else do we tell about that? Do we tell not just the Department of Health, but do we tell coworkers? Do we tell vendors? Do we tell customers who have come in contact with that person? And I think, again, the answer is going to be yes to that question. And I think the challenge is in identifying, who do we tell? Do we tell every single employee in our entire organization that that's occurred? Or do we provide some kind of analysis of who we're going to communicate with on some smaller scale? I think as a practical matter, once you tell any number of your employees, the rest of them are going to learn indirectly through the spread of information. So it may be that we err on the side of being more communicative rather than less. But again, and I keep harping on this point, but I think it's very important from the legal side, the CDC does have some publicized information about what counts as exposure, what counts as a high-risk contact, what counts as a low-risk contact, and most importantly, what counts as a no-risk contact. And so it's important for us to maintain a rational approach to who we communicate with and communicate to them what level of exposure they may have had. If you were to compare that to, say, our law firm, if we had a confirmed case on the 12th floor of our building for a person who never comes in contact with anyone on the 8th floor, do we need to tell the 8th floor that they've been exposed without at least very calmly and very rationally explaining to them that they have a no-risk exposure situation according to the CDC? Well,
and you're going to be getting, as employers, when you run into a situation in which you have a confirmed positive COVID-19, you're going to be getting advice from the CDC and from your local health department that you need to identify who has come in potential contact, whether it's coworkers, customers, business associates. Kirk, what's your thought on this sticky issue, this tough issue Paul's talking about? I found somebody in my workforce that's positive. What's your view on identifying that individual to others?
Yeah. Well, it's so different. I mean, the world is different because we normally would not disclose, quote, confidential medical information about an employee. But I think in the interest of health and safety and the interest of communication, as Paul talked about, I think it's really important that we do two things. One, we have the employee that is exposed, or we have the employee that has tested positive, provide us a list of people with whom they have come in contact over the last 14 days and try to identify those people who may also have exposure, but also we may have to communicate with a broader employee base about that Charlie has been exposed or Charlie has confirmed positive, and here's what we're doing to address that in as calm and reasonable ways we can, which is very different than our normal world about communicating about health conditions of employees. What are your thoughts about that, Charlie?
Well, what I ran into Friday was a situation with an employer struggling on the issue of identifying to a larger group I confirmed positive, and we went with a more aggressive in terms of information, not panicking, very, very factual, as you know, the path that Paul outlined. And one of the things we discovered is when we shared that information with the workforce, we identified other points of contact we would not have known or was not remembered by other people. So there are, I think, Paul's approach and your additions, I think we are living in a new world. So I think I get a little bit more aggressive on sharing that information, not to create panic, not, as Paul says, not to overemphasize or exaggerate exposure, but to be very factual. And I think from an HR standpoint and a legal standpoint, as we go down this path, our workforce is going to be more appreciative of candor. Our workforce is going to be more appreciative of planning. Now, I've got a little bit of a twist on that, Paul. Your employee is not tested positive, has not exhibited any sort of symptoms, but we learn directly or indirectly through the grapevine that they have been caring for an ill family member. How does that change the dynamics of what we're talking about?
Yeah, I'm not sure it changes the dynamics a great deal at all. I think if we, giving the contagiousness of this particular condition, when we learn that we have an employee who is caring for a person with active symptoms, I think we have the exact same rights we've talked about before, which are we have the right to then ask that employee to go on leave. And again, that might be completely involuntary if that employee objects. But I think we can assume an exposure at that point enough that we should take the precautions and keep that employee out of the workforce.
Okay, so Kirk, now we've got somebody in all these examples, whether it's somebody with active symptoms or we've learned that they've tested positive or they're caring for somebody with active symptoms, for whatever reason, we're sending them home. Does the employer say, hey, Charlie, I need you not only to go home, I need you to get a flu shot, and I want you to go see a doctor, and I want to see that doctor's report. How about that issue?
Yeah. Well, as we know, we can't require medical exams under the ADA. We can certainly encourage them. We can certainly motivate people to do them. We can certainly help them with the cost of those kinds of issues, but we can't force somebody to go take a flu shot or go see a doctor. But what we can do is say, you need to be gone for a period of time, and you need to return symptom-free. And that may mean that we need you to go see a doctor, in that case, returning, or at least some evidence that you're symptom-free. So the communication strategy is really important here as we're communicating with all the folks that may have symptoms that cause us to want to send people home.
Many of these questions we're wrestling around with right now really hinge on employee benefit and some confidentiality issues. So we've asked Jim Prince with our employee benefits group to help us out and answer those issues that are arising right now. Jim, you know, a lot of our employer clients are facing new health benefit issues as a result of COVID-19. What sort of employee health or insurance issues should they be on the lookout for?
Well, there's a couple of new developments that they need to be aware of. First, the IRS last week issued some guidance in the form of a notice that indicates that employers who sponsor high deductible plans, and a high deductible plan is one that allows somebody to be eligible to make contributions to a health savings account. So for those employers, normally the employee has to meet their deductible before the plan can pay anything. The IRS notified us last week that with respect to the cost of testing for the COVID-19, the plan can pay for that and not disqualify the employees from their health savings account contributions. So that's one issue.
So that kind of does away with the high deductible aspect when it comes to testing.
With respect to the testing, it can be covered 100% by the plan and not disqualify the person from having a health savings account. the new law that was passed over the weekend also provides for private plans, private employer plans and insurance to pay for the testing at 100%. So assuming that follows through and becomes law, that will cover the testing issues.
You know, one of the things I think a lot of our employers are dealing with now as this COVID-19 blossoms, unfortunately, is issues of communication to the workforce when someone has been exposed or there's been an exposure issue. What can you tell us about confidentiality or medical information issues that may arise in the context of an employer dealing with potential exposure or actual exposure by members of its workforce to COVID-19?
Sure. Well, first of all, they need to remember, and many employers are always worried about HIPAA, the HIPAA requirements. So they need to remember that HIPAA applies to health plans and healthcare providers. So an employer who's acting not either as a health plan or as a healthcare provider is not subject to HIPAA. The actions that they take are not subject to HIPAA. So, for example, knowing that a person has been exposed and it's therefore not going to come to work, that's not an issue that is covered by HIPAA unless they found out that the exposure, they found out about the exposure through the operation of their health plan.
All right.
So that's the initial thing. They keep in mind you have two different hats that they're wearing. One is an employer and one is a healthcare plan provider.
So if an employer is finding out this information through its routine supervision process or attendance process,
right,
or HR function, the HIPAA confidentiality requirements would not occur.
Would not apply.
All right.
Would not apply to that.
All right.
But we do still have privacy issues under the ADA where employers need to maintain confidentiality around information that they receive and not share it to a broad group. That's the general law. We're going to talk about maybe some exceptions to that as we talk today.
Right.
And then an additional exception under HIPAA is the imminent danger. If they think that there's imminent danger to the employee or others based on the information that they've received via the health plan that is covered by HIPAA, there's an exception for an imminent danger situation where they would need to notify somebody that this person has an exposure.
And Kirk, that's a similar standard we have under the Americans with Disabilities Act, the direct threat language. I think it's probably very
right,
similar in terms of standard on
right,
dealing with information.
Right.
All right.
And then, we anticipate other questions coming up, at what level our treatment's going to have to be paid, issues related to whatever the drugs are that are going to have to be utilized to treat the COVID-19.
So, Jim, you're following this very closely, is that right?
We are.
And if employers have questions as new issues develop or as they face specific challenges in our own workforce, you're available to help them.
Absolutely. We're here, and we're following it closely, and it is evolving fairly rapidly.
Kirk, kind of a follow-up. We're talking about sending people home and telling them not to come to work because of exposure or perhaps positive tests. Now I'm one of those coworkers, and I'm seeing you send people home because I'm concerned about COVID-19. And I say, hey, I don't have any symptoms, and I haven't had any exposure, but I'm uncomfortable with coming to work because I know Charlie here, who's now home, his hand was on this doorknob, and he was all over the lunchroom. And what do you do as an employer if you have employees that are not exhibiting any sort of symptoms, not had exposure, but are concerned for their own safety and the safety of their families, and say, I just don't want to come into an environment that's potentially COVID-19 enriched?
Yeah, and we've had this discussion. Our clients are calling about this particular issue. Paul's had this issue this morning in a direct situation. Again, my advice would be to communicate clearly that this person does not have an exposure. We don't have any evidence of an exposure. We would define what an exposure is through the CDC information. We would try to educate the employee. And then I think at the end of the day, if the employee doesn't feel comfortable being at work, then we would let them go, but they would not be protected in the sense that other employees who do have an exposure or have been tested positive, they would be leaving unpaid and not being compensated for their decision. And I understand the decision, but unless we have some evidence that they are exposed or they have an exposure or some risk of exposure, I don't think it's correct just to allow everybody to be gone with pay.
Paul, your thoughts on that?
No, I think that's absolutely right. I think we have such difficulty right now in the age of social media and otherwise of determining what information is good information and what information is bad information, and we have employees trying to make decisions based on information that they may or may not know is good information or is valuable information, and so we're going to face situations where employees don't want to work, and we may not agree that is a rational decision based on the information we have for that employee. But I think this is a very unique situation where we are not just going to be judged based on a legal standard. We have a situation now where we're going to be judged on a social standard, and so this is there's certainly social pressure out there to be flexible, to allow employees to have more leave than they otherwise might have. And while I think it may be difficult under circumstances like what you described, Charlie, to give that person paid leave, I think it might be appropriate to go ahead and give them an unpaid leave that doesn't have an absenteeism consequence, but is really because there's no real legal obligation to pay an employee who's leaving under those circumstances, that vague risk-free kind of just generalized fear. I think that employee may be able to go ahead and have the time off that they're requesting, but they're not going to be in a situation where we can justify requiring you to pay them.
Yeah, and Kirk's information, I think, is very important. That is getting information out to employees. And we have a lot of employers right now that are following the directions of the CDC and their local Department of Health in terms of what sort of cleanliness or cleanup protocol they should be employing for their workplace. I think that's really effective to explain to our workforce who do have legitimate concerns, even if they're not suffering right now, that here's what we're doing in terms of enhanced cleaning protocol, and we're following the protocol recommended by the Department of Health to make this a more clean environment. I think that helps in terms of information.
Yeah, the only other two legal issues I would touch on is if the employee can establish that there's some imminent harm, then they have some protections under OSHA.
Right.
And then if it's a group of employees, it's more than one, whether they're unionized or not, and they come to the employer and say, we collectively are not comfortable working here because Joe's had an exposure or Joe's worked in this environment, there may be some protections under the National Labor Relations Act where employees can engage in what's called concerted activity, which means that they are joining together for the purposes of benefits or compensation or other terms and conditions of employment, and certainly safety and health would be a term or condition of employment. So we just need to keep that in mind. If we have more than one person coming to us telling us we don't want to work, there may be some protections under the law.
Yeah, I think Paul's point is a good one, is you as employers are going to be looking this both from the legal ramifications that Kirk hit on, but we're also going to be dealing with this on a personnel or a social aspect, and keeping both those in mind. And I think this is going to be one of the questions we're going to see really pop in the next week or two, where we do have members of the workforce that are going to be expressing concern on continuing to work. So that's something to be ready for and figure out how to address it. I'm going to change gears a little bit to compensation, Paul, and we're going to talk about some of the leave benefits, but just under the Fair Labor Standards Act, if we've got employees who are homesick or we've sent home involuntarily, what sort of obligation under just typical Fair Labor Standards Act or compensation laws, what sort of obligation do I have to pay somebody that perhaps I sent home, whether he or she wanted to go home or not?
Yeah, so important to distinguish what I'm about to talk about from the paid leave question, which is a separate question. But just from the perspective of who's entitled to be paid when we're not working, right? Remember that for non-exempt employees, the question is, the general rule is, if they're not working, they're not paid, right? And that rule still applies when you have a closure of a facility. So if you have a temporary shutdown and your non-exempt employees are not working, you're going to need to analyze the question under the paid leave policies that you have in place now, under the new paid leave laws that may be passed over the next day or two. But with respect to just generalized obligation to pay your employees, that's not going to be there for non-exempt employees. For exempt employees, you have a different analysis. As you should all know at this point, anytime an exempt employee works any part of the week, they're entitled to their salary for the entire week. And so when you have a temporary shutdown that affects only part of a week, you're certainly going to be in a situation where your exempt employees could be entitled to their salary for that entire week. If the shutdown goes longer than a week, the question becomes a little bit harder to answer. But with respect to your exempt employees, there may be some pay obligations for them, regardless of whether you have a shutdown that affects everyone or not.
And we can require them to use their benefit time, as long as they're not losing their salary level. We can require them to use their PTO or vacation time during that leave.
Absolutely. So, and that's always the case with exempt employees when they have an absence. The FLSA does not limit our ability to have a paid leave program, and we can establish a paid leave program under any circumstances that we want without offending the FLSA. So we can require exempt employees to use that paid time off that's available to them under our standard paid leave policies, even if it's a shutdown or a temporary furlough type situation that's brought on by this condition. That may change to some degree if they are eligible for the new kind of paid leave that we're learning about and will become effective over the next few days. But under our general paid leave plans that exist today, we can require our exempt employees to use that banked paid time off even in circumstances where we have a shutdown.
So Kirk, I want a kind of a related follow-up question to what Paul just talked about, compensation. We're having a lot of employers asking us about allowing, whether they're exempt or non-exempt, employees work remotely. So first of all, do I have an obligation as an employer to provide remote work, again, whether they're exempt or non-exempt, or is that my call?
It's clearly your call. The only potential situation where you might have an obligation legal obligation as to where it would be a reasonable accommodation under the ADA. Somebody has a disability, and that might be considered a reasonable accommodation under the ADA. But generally speaking, the ability to allow people to work remotely or to telecommute is really within the sound discretion and business discretion of the employer as to who and how and what the parameters of that would be. The thing I would, as we're thinking about this, if we end up having employees with this social distancing issue working remotely, we ought to have clear policies. We ought to have clear communication with employees about, for example, time compensation, clock in, clock out, what the expectations are in terms of reporting, obligations, and communication are going to be huge if you've not been in a remote work environment and you're moving to a remote work environment. Policy and communication with those employees is vital in terms of making sure that they're meeting your expectations as an employer.
Well, Kirk, what about a situation where you are faced with employees saying, well, you're letting Paul work remotely, but you're not letting me work remotely? How do you address those issues?
Well, you do it on a case-by-case basis for sure, and you sometimes have to make decisions where you say, Paul needs to, for a variety of reasons, some of which I may be able to tell you and some of which I may not be able to tell you, but that you're going to communicate, but we need you to be here. You're vital to this particular area and need to be here on location, and it's critical to our mission, so I wouldn't let that stop you from making those choices. We do need to articulate why, at some point may need to articulate why certain people are working remotely and others aren't. But those are certainly within our sound business judgment.
And one of the things we've been talking for years, this isn't new, but certainly applicable now in remote work. There's nothing wrong with me telling Paul, hey, Paul, we're going to try this and see if it works. It may not work for us. There's nothing wrong with trying remote experimentally and saying, Paul, it doesn't work for us. So don't forget that as an option also.
Yeah, it's not forever.
Right.
And this may be a really temporary, 2-week, 2-month situation where getting through the seriousness of the virus, hopefully it will subside over some period of time and we'll be able to kind of get back to normal. So this may be really an interim or temporary step.
So we've emphasized the importance of communication and information to our workforce. In this world, what should employers be doing about their existing policies and informing their workers right now what to do and what fits?
Yeah, I think, and I don't know if Paul agrees, but I think that we have to communicate clearly what our policies are as it relates to the COVID issue specifically. We need to deal with travel. We need to deal with the things that we've been talking about today, what our policies are going to be on those issues and how we're going to handle it. I think it's better in those general policies than individualized as we're making decisions. And then, at some point in the next week or so, we're going to have to consider our FMLA policy. And again, we don't exactly know what that's going to look like because Congress hasn't yet passed this law. It's gone through the House. It's in the Senate now. But if there is, for example, paid time off, we're going to have information about that. If there is caretaker time off, we're going to have to deal with that. If there is less than 50 employees, we're going to have to address that for those employers that have less than 50 because they're not currently covered by the FMLA. So it's just going to, the employers are going to need to relook at really all of these issues, their ADA policy, their telecommuting policy, all of those issues that we're talking about today need to be at least considered in updating or revising or recommunicating what those policies are.
Paul, what other implications do you think are out there?
Well, no, I just think the main point of all of that is our employees need to know what we expect of them. They need to know what not only their rights are, but what's expected of them in situations where they need leave or they need an opportunity to be gone for a while, or they need to know how to respond when they become aware of an employee's symptoms, right? We just need to be communicating to them. And that doesn't necessarily mean the ordinary process of formally adopting new policies and reissuing handbooks and those types of things. We don't have time for all of that, I don't think. But we do have the opportunity to communicate to our employees what's going to be expected of them right now with respect to these specific issues. And so it's not really business as usual. It's a very different approach to a very unique problem.
Yeah, I think we shouldn't lose sight of the fact that besides being a business, employers have some social responsibilities. And I think the best way we can allay fear and slow panic is, as both of you all have made the point, communication, open communication, information. That's the best way that we as employers can not only fulfill our business obligations, but our obligations to our workers, our employees, and our business associates. Now we got to think, we're not really hitting this yet, but it's coming quickly, and that is situations where people who have missed work because it was either their idea or our idea, now they want to come back to work, Kirk. And what sort of rights does an employer have to say, Charlie, you don't get to come back to work until I get a doctor's report or doctor's note saying you're safe to be here from a COVID-19 point? Do I have that kind of right as an employer?
Yeah, it's a good question. And there are different schools of thought on this, honestly. Like the CDC, for example, their position is the employer should not require the employee to get a doctor's note, not really for the same reason why we would require one, but because the healthcare providers are inundated right now with being able to provide, and the fact that we're going to stress them even further by asking them to get see this employee and give a doctor's release or a fitness for duty evaluation, what the CDC is recommending is that they just be symptom free, that they communicate with you honestly, you communicate with them, and then return them to work. I think some employers are going to decide, you know what, this is too serious and too significant, so we're going to require them to go see a physician on a fitness for duty evaluation. I think given the direct threat that we have, a potential direct threat, I think our ability to do that is certainly available.
Another option we may think about, Paul, on this regard is, what do they say, 14 days for symptoms to show, up to 14 days for symptoms to show. I may say, hey, you're out for 14 days. If you want to come back before 14 days is up, I need a doctor's report as an option. What other practical things should our employers think about when making decisions on whether someone who's been gone for a COVID-19 issue is ready to come back to work?
Sure. So I understand largely why the CDC would take the position they've taken, Kirk, which is that, we would rather you not inundate healthcare professionals over doctor's notes, for lack of a better word. But I wondered when I read that language if the person that wrote it was thinking about doctor's notes the same way that we think about them as lawyers. We don't often ask for doctor's notes because we're asking for proof that you actually had a reason to be gone. And that feels trivial in the middle of a circumstance like this. But instead, we're asking for doctor's notes to prove that it's safe for you to return back to work for everyone else, right? And so, to me, I think if we've got a situation where we have a person that we know has tested positive and they are prepared to return to work, I think that's a serious request. And I think asking for a doctor's note that allows an employee to return to work is very different than asking for a doctor's note that says Paul wasn't faking. Paul actually had a real reason to be gone over that 2 weeks. And then I think the additional thing I would say is that if you do want to take the employee's word for it, and we choose not to inundate the healthcare professionals for the clearance to return an employee to work, then I think we need to not just forget about that employee. I think we need to be paying attention to whether that employee is still exhibiting symptoms in the workplace. And it may be that the employee, for financial reasons, for mental health reasons, for otherwise, they may have pushed the envelope and asked to return to work just a little bit too early. Right. And if we didn't ask for a doctor's note, for whatever valid reason we may have chosen not to do that, and we discover that that employee has returned to work too early, they still appear to be exhibiting signs of a respiratory illness, we've got to react to that. And we can't just forget about that employee because they've been gone and now they're back.
Okay. That's where training our managers and supervisors is vital. I mean, we need to be talking to our leaders now about this COVID issue, about how we're going to handle these issues, about what are the signs and symptoms they need to be looking at and talking, and that they need to be communicating with our human resources professionals, our legal team, about navigating these issues. This is, it's a new world. And so your leaders are going to have to be really on top of all these issues. And we need to be aggressive at communicating about people's health condition, given the pandemic that we're in.
And getting good quality information from our healthcare professionals, from the CDC, from our Department of Health is critical. And like you said, Kirk, like all HR and employment issues, good, candid, and timely communication with the workforce is critical. Paul, any closing thoughts or points you think are important for our listeners to know?
No, I think the main thing I'd like to leave you with is just know that this is an evolving situation. And I mean, for example, what we expected to talk about this morning when we planned this on Friday has changed dramatically over the last 48 hours. And I think that's going to continue to be the case. We are keeping an absolute critically close eye on this. And as things change, we'll be updating you even more through all the lines of communication that we normally have with you. If you have questions, please reach out to us. The chances are that the questions you're facing are questions that all of our other clients are facing as well. And so we want to help you walk through those and make the best decisions that we can.
So thanks for listening, and we're here for you if you need us, and stay safe and healthy. Thank you.